Good day. Today we're going to be talking about Injuriarum. Like we noted from the first chapter, that delict is founded really on two principles or two wrongs. One being the wrong of substance and one being wrong of personality. Now, Injuriarum is wrong of personality, right? One of the actions available under these types of wrongs are defamation, impairment of dignity, invasion of privacy, and so forth. As we continue. Now, in terms of defamation, who can sue for defamation? We have natural persons, we have trading and non-trading companies, as seen from the Loma case, and we have also political parties. They can also sue, but it is important for us to take note that the government cannot in itself sue, but a political party can. Now, there are different ways to define defamation depending on who perpetrates the defamation. Now, if an individual defames someone, it is referred to as the unlawful and intentional publication of defamatory matter referring to the plaintiff, which causes him or her reputation to be impaired. Now, if it is in terms of defamation by publishers or distributors or published materials, this is the unlawful and intentional or negligent publication of defamatory matter referring to the plaintiff, which causes his or her reputation to be impaired. Now, in terms of defamation by mass media, we have the unlawful publication of defamatory matter referring to the plaintiff, which causes his or her reputation to be impaired. Now, as you hear from these three types of defamation, there are differentiating factors that are there. When it is perpetrated by an individual, the type of publication has to be not only unlawful but intentional, right? And that's it. But when it comes to perpetration by a distributor of published materials by a publisher, then the type of publication must be unlawful, intentional, or even negligent. So that's the differentiating factor there. And when it only comes to mass media, there is strict liability. We have only unlawfulness as a criteria to limit the type of publication. So the publication only has to be unlawful, therefore, for it to be deemed as a publication of defamatory matter. Now, these are the types of mass media that are there. Usually, individuals defame people through mass media, but it is under the first definition that we talked about. Only when the mass media itself, or television broadcasters, ZBC News, or all those different types of GZU radio stations, all those types of mass media, only when they themselves as a media outlet defame someone, that's when we see the third definition come into place. Now, outline the elements of defamation. For a person to claim defamation in court, they have to, on a balance of probabilities, prove these elements. Firstly, there must be publication of defamatory matter, so there must be publication. And then, from the moment that it is established that there was publication of defamatory matters, there are two inferences that are inferred. One, that the publication was unlawful, and two, that there was intention to defame. So, publication of defamatory matter, and the matter itself has to be defamatory words or conduct, right? And then we have reference to the plaintiff, and lastly, causation. But when you're looking at the elements of defamation, these are all of them in whole, all 6 of them. Firstly, publication, right? There must be defamatory words. 2, 3, there must be reference to the plaintiff. And from the moment that you establish these 3 things, the 4th and the 5th, which is unlawfulness and animus, are inferred as the elements. And then we have causation, which is mostly you saying that this type of defamation has caused my loss to reputation. Now, as a matter of fact, these are notes under defamation. In mass media, there is strict liability. We talked about this, that is not based on fault, right? And then we have the major defense to exclude unlawfulness, truth, private defense, and necessity. So all those defenses available to exclude unlawfulness in the other types of wrongs that we dealt with are also applicable. So here we have truth, private defense, or necessity as a defense that can negate the claim. And then we have, in cases of non-mass media, a defense excluding animus are also available. So we have in mistakes, intoxication, insanity, and so forth. So in terms of defamation, you can claim compensation, or you can claim an interdict, restraining someone from publicizing those defamatory matters. So from the slide, you can see that you can say, I have made a huge mistake, as a defense for any publication that was made by either an individual or by a publisher of materials. Now, publication is an element under defamation. They say that the publication must be of the statement of conduct to a person other than the person defamed. So this publication, it must be to a third party. This is the most distinct feature of defamation as opposed to other actions, for like an action for the impairment of dignity. Now, publication is the act of making a defamatory statement to person of persons other than the person who is subject of the defamatory imputation, right? So you cannot say that you have published a defamatory matter if you are only telling the person who is there the defamatory stuff. You have not publicized, you just only told the truth to that person, or you have told a lie to that person. So that is the first thing that you have to understand. And then we have publication can occur by omission where there is a legal duty to act. So it is important thing to note that publication, according to the principles of dialectic, can also occur where you omit something where there was a legal duty to act. It says here that there is no publication unless someone to whom the words were communicated understands their meaning, right? Let's say you tell someone something and they just do not get it, they do not understand. You have not fully communicated that publication, so it does not count as publication. This is noted from the case that was there on the previous slide. Now, in terms of couples, in English law, a communication between a husband and a wife does not constitute publication. It falls within the defense of qualified privilege, right? So a spouse has the privilege, right, to know the things of her husband. And not only that, we talked about this in class. In terms of English law, they considered couples to be one person. So you cannot claim to have told a third party when you are saying that defamatory matter to the spouse of that party that you are defaming. And then everyone who participates in the defamation is liable. It talks about republication. Now, under republication, there's a case there. It says that a person who republicizes a defamatory rumor without endorsing cannot escape liability on the ground that he merely placed it on as a rumor. So long as there was something bad that has been told to a third party by another person, there is publication, and be it republication, it also counts. Now, defamatory words or conduct as an element. It says here that meaning may vary with the temper of the times and the prevailing social moral values. We talked about this. We know that years back there were some words that we use today very lightly, though at a certain period of time they were deemed to be defaming words that insulted, that shunned people. So now for the court to consider whether words are defaming or conduct is defaming, they have to look at the prevailing social times. Today, would this person be considered to have defamed someone? And like I was saying, there are some cases which are now considered to be traditional. So people walk around saying different things today that would be considered innocent, but back then were curses. But even back then, there were some curse words that are now considered today as. Now, defaming words or conduct, as noted from the cases that we are familiar with, it can constitute two things: to establish whether the defamatory words or not, the court looks at the meaning of the words, the actual ordinary meaning of the words, and then they look at the secondary meaning, the innuendos, the definition of the word in between the words, if I could say so myself. So there is the on the face value ordinary meaning of a word, and there is that secondary innuendo meaning of the word. That's where what the court looks at. And then they also look at whether the meaning is defamatory or not, right? So the test for us to establish whether the meaning is defaming or not is whether the imputation lowers the person's lowers the plaintiff in the estimation of right-thinking people, right? So would a right-thinking person deem that plaintiff to have been lowered, right? His reputation to have been lowered, then that is the test. It is laid out in Marucci versus Harris. And then reference to the plaintiff. No person can bring an action unless the statement or conduct refers to him or her. I gave an example in class, and this statement also relates to the fact that if you have been defamed, you have to show that no, this person, sometimes it can be straightforward stuff. Someone comes to you, like it is noted from the ad, Alex is just stupid, right? Or someone goes to a third person and says, Alex is just stupid, right? Straightforward stuff. This person is defaming Alex. But then this is different because someone may come in a classroom, you are the only fat dark person there, or you are the only light brown skinned person in the class, and then he comes in and say, the white or dark people in this class are stupid and unintelligible, or whatever, all those kind of things, incorrigible, all those things. And then everyone knows, a right thinking person knows that this person is referring to the only dark or light person in this classroom. So the plaintiff would have to prove that the defaming words were referring to him or her. Now, the text is objective, as noted, and then the quote Young versus Kemsley, the test is whether the ordinary reasonable man hearing the speech would have understood the words complained of to apply to the plaintiff, right? And then there is no defamation of a group. So a whole classroom of people, if I come into a classroom and say this class is stupid or whatever, you cannot go and claim defamation for that. It has to be specific reference to you, right? This was noted in the SA Associated Newspaper Limited. Says where the defamatory matter refers to a class or group, plaintiff may only succeed if it is proved that though it is expressed in respect of a group of which he is a member, it is in effect a publication thereof concerning him personally. So even if you're part of the classroom that is stupid, you have to go to court and say, no, he came in and said the group is stupid, but he personally referred to me. He was trying to reference to me personally. So that is how you prove your case therein. And then the dead cannot be defamed, right? That is straightforward stuff. And then we have causation as a element. This element in itself has received little attention under the claim for defamation. So the plaintiff is usually presumed to have suffered injury to reputation. A person can claim general damages which are presumed to flow from the publication of defaming matters, right? When we were talking about the difference between general and special damages, we noted that general damages are damages that naturally flow from an action. So if a person publicizes defaming matters to a third party, then it generally flows from those actions that your reputation will be defamed. So as a general remedy, you can claim that the defamation has caused my loss in reputation. So the presumption means that the plaintiff is considerably assisted in the task of proving causation, right? It says here that in principle it is possible to argue that the defamation did not lower anything, seeing as they already held him to a low esteem, but it is mostly relevant in mitigation of damages. So here they're saying on the last note that in principle you can claim that you can argue that there was no defamation because this person had a very low reputation to begin with, but it is most relevant when you are trying to mitigate the damages. As a defendant, you can say, no, yes, I have defamed you, but the compensation that you are claiming is too much because you already have a low reputation to begin with. Why not lower the compensation that you are claiming? Now, unlawfulness, we noted from the get-go that there is an inference of unlawfulness that is there from the moment that you establish that there was defaming material to a third party referencing yourself, right? There's an inference. So there's a presumption that the publication was unlawful. Now, unlawfulness is the infringement of a legally protected right. The general criteria is the one that we are familiar with. There is a balancing of the reasonableness of the community, the legal convictions of the community, the legal policies, the legal policy. All those things are used to establish whether there was unlawfulness or not. So the judicial function therein is just to balance the interest rights of those concerned. And the burden on the defendant is only there to prove that it was lawful. Now, animus, like I said, it is also inferred, and then it says that defied is subjective intention to injure the plaintiff with knowledge of unlawfulness. So here they're saying that there has to be a subjective intention. The person must want to have defamed you, right? So that is the animus. It is inferred. In terms of the available defenses, we have truth for public benefit, right? In terms of English law, the only defense there it would be truth. The fact that the defaming material is true would be a defense on its own. But under this Magan law, the defense that would be there would be truth for public benefit. So you have to prove that not only is it true, but it would benefit the public for your defense to suffice. It says that the court usually favor a broad interpretation of what it is that would entail public benefit, right? One should be allowed to live down his or her past. So here they're saying that even if it is true for public benefit, the court also considers the fact that sometimes it is noted in Graham versus Kerr. The court stated that it is generally for the benefit of the public that others who might have dealings with the guilty individual should be informed of his true character. So the court knows that, yes, it understands that, yes, people that are dealing with bad individuals should be made aware of those individuals' conduct or what it is that they're doing. Now, but the court also understands that even if it is true, a person must be able to live down their past. They must understand that people change over time. That's why even the prison services is called the correctional services, because they know that it's such misconduct that a person would have done in the past can be corrected over time. So a person should be able to live down their past. So they'll be weighing down the interest of the defendant, the interest of the plaintiff, and trying to come up with the best judgment possible. Now, in terms of Levy versus Modus publication, newspaper was criticizing a rich man for a project that he had attained to develop shopping centers. There were those projects he had attained unfairly, and the court held that the comments were true and fair, and therefore the newspapers were not liable. So that's an example of the defense for truth for public benefit. If public officials or if rich men are taking advantage of the poor, the general masses, it is important that everyone knows what they're doing. So the court held that it was true and fair. Now, in terms of defenses, another defense that is available is the defense that the defaming words that were said to a third party were fair comments, right? They say, no, it was fair. I have deduced fairly from your conduct that you are indeed stupid. But for that defense to suffice in court, the requirements for that defense would be: 1, the allegation must amount to a comment or opinion, right? And the test for that is whether the reasonable reader would regard them as assertions, right? And then secondly, the comment or opinion must be fair. And according to English law, fair means it must be honest and genuine expression of opinion that is relevant, right? And not something that is there to only disclose malice. So here they're just saying that not only is it an opinion, but that opinion must be honest and genuine, right? Unlike the one for public benefit, there is a stricter test for fairness. The court are strict in terms of establishing whether a defaming word or conduct is fair or not. It says here that the factual allegations must be true and that it must also be of public benefit. So in terms of requirements, the requirements are laid out. Not only must it be fair, it must be true, it must be of public interest as well. So the fair comment defense is stricter than that of the truth for public benefit defense, because not only must it amount to an opinion or a comment, it must be fair, it must be true, and it must be of public interest. Now, another defense that is available is the defense of privileged occasion. You can say that I had the privilege or I had the authority to defame you because of the special circumstances that I was in. There are two types. We have absolute privilege and then we have qualified privilege. Absolute privilege is saying that any communication that is uttered on a specific occasion should not be presented for defamatory proceedings. We have an example of parliamentary proceedings. They are considered to have absolute privilege. And then we have qualified privilege. The examples that are there: statements made in the discharge of duties, statements made during judicial proceedings, reports on proceedings of court. They are considered to be qualified privilege. Now, there are other defenses that are there that we are familiar with. We have consent, right? We have rixa, we have just, and we have compensation. All those defenses that are there to negate the claim for defamation. So these are the defenses that are available. Now, damages for defamation, like we noted before, there are two remedies that are there, but they are not exhaustive. We have an interdict. You can go to court and claim an interdict which restricts a third party from publishing any defamatory or defaming matters regarding yourself. The objective for damages for defamation is not for punitive reasons, but vindication of the plaintiff's reputation and providing solace or solatium for wounded feelings. Like we said, it relates to wrongs of personality. We are looking to compensate the victim for the loss and reputation that they have incurred or that they have encountered. Now, factors considered in the assessment of damages. One may ask, how do you then assess how much a person is worth, how much damage has been caused, and all those things? Now, the court looks at the character, status of the plaintiff, the nature and extent of the publication, the nature and imitation of the imitation, and the probable consequences of the defamation. Where there has been an apology, they also take that into account. So the probable consequences of the defamation, they look at what happened when your reputation was defamed. Maybe you had also some type of value, you were a social media face, right? Because of your defamation, you have incurred a loss in your whatever brands that you were representing. They consider all those things. So those are the factors that are considered by the court: your own personal character, your status, and so forth. Now, factors considered also for mitigation of damages. So there are also other factors that the court looks at to try and lower the amount in damages being claimed. the fact that you also had a bad reputation to begin with, the absence of intention by the defendant, and the fact that the defendant was not the originator of the defamating content. They look at all those things. And other aggravating factors like presence of malice, repetition of offending statements can also help in increasing the amount of damages that are there. So this, ladies and gentlemen, is defamation. This is action Injuriarum. We'll continue on with other actions that are available.